Hello and welcome to the latest in our Think Law video series. Today I'm joined by my colleague Ciara O'Donoghue to discuss the company's Corporate Governance, Enforcement and Regulatory Provisions Act of 2024, one of the last things approved by the outgoing government. As a member of the Company Law Review Group, I'm aware that this Act is dealing with some issues identified by that group. It is also dealing with issues identified in a public consultation that was launched by the Department of Enterprise, Trade and Employment last year. Ciara, the Companies Act of 2014 was a consolidation and modernisation of our company law code and the most significant done since 1963. Because of COVID, we had the COVID Act of 2020 and now we have amendments to the 14 Act. Can you give us a flavour of those changes?
Yes, Sal. So the Act makes some important updates to company law and overall it modernises our company law code. As you mentioned, arising from the temporary provisions of the COVID Act of 2020, the changes will permit companies on a permanent basis to hold hybrid or fully virtual general meetings. And that provides clarity for companies who hold virtual meetings without bringing shareholders together in one place. One point to note, though, is that those provisions don't apply to creditors' meetings or to meetings to consider schemes of arrangement. So that perhaps acknowledges the need for those meetings to be held in person. Another welcome change is the ability for officers who are in different locations to execute company documents in separate counterparts. And also in the Companies Act of 2014, that introduced the ability for companies to merge, and the changes will permit a merger where one party is a LTD, as well as multiple subsidiaries with a common parent being able to merge in one transaction.
Thank you, Ciara. That's very interesting and certainly shows a desire to have a modern company law code. There are also some changes coming to the company's registration office. Can you tell us what clients can expect?
Yeah, there's a number of changes in that area. As you know, a lot of companies use professional advisors to file documents with the CRO on their behalf. And now those electronic filing agents are going to have to get authorisation from the Department of Justice. However, for solicitors and for accountants who are already regulated, they should be able to continue as electronic filers without further authorisation from the department. Also, in measures which are clearly designed to keep the register of companies up to date and current, the Act introduces 3 new situations where a company can be involuntarily struck off. So if a company fails to notify a change in registered office, fails to record a company secretary, or fails to file beneficial ownership information, they can be involuntarily struck off. And interestingly, if a company is struck off for any one of those new grounds, the directors won't be subject to disqualification proceedings.
That should hopefully keep the register more up to date. One of the issues identified in the public consultation and also by the SME sector was the loss of audit exemption where a company was late in filing its annual return. Are these changes dealing with those concerns?
They are. Up to now, audit exemption for small and micro companies is lost where a company files an annual return late in any one year. And a welcome development, a company will now only lose its audit exemption where within a 5-year period it fails to file an annual return on time for 2 years. The aim there is to reduce the burden on SMEs, so that change doesn't extend to a group situation. So it's important just to watch for that distinction.
Great, thank you, Ciara. There are also some changes coming to the Corporate Enforcement Authority. Can you outline some of those for us?
Yeah, there's a number of changes in relation to the CEA and they intend to enhance its ability to gather information. Auditors currently have to notify the CEA where they're of the opinion that an indictable offence has been committed. Now auditors will also need to provide copies of relevant information to the CEA. And also any person who interferes with or obstructs an officer of the CEA will be guilty of an indictable offence.
Thank you for bringing us through those changes, Ciara. The Act passed swiftly through the Oireachtas and just before a general election has been called. However, it didn't contain all of the items that were in the general scheme that were published in March of this year, presumably because it would have delayed its swift passage through the Oireachtas. Ciara and I hope you enjoyed our update today. The full suite of KPMG Law's Think Law video series is available on our website.